In the beginning of 2020, Assembly Bill 1482 was introduced to California's new rent control law, bringing new limitations and new restrictions. Now, with COVID-19, there are even more restrictions and limitations. So as we've been speaking to landlords and apartment owners, there is that common denominator question: what can I do right now? Can I begin an eviction case, an eviction process? And what is the process like during this environment? Well, if you're a landlord or apartment owner and you're wondering the same questions, you're gonna find out in this video. In my previous interview with real estate attorney Bruce Menke, we discussed the changes in the eviction process and what we can expect moving forward. So let's get into it.
Okay, as far as the eviction process, it has changed dramatically. In early April, I believe it was April the 4th, Judicial Council, which is the organization which is chaired by the Chief Justice of the California Supreme Court, that is responsible for the administration of the court process, the courts themselves. We have a number of code sections which historically have managed the unlawful detainer process. And most of those rules have been turned on their head by the rules that have been issued by the Judicial Council, which will remain in effect until they change the rules, which hopefully they're currently in the process of doing. There are some rumors about that. Or for a period of 90 days after the expiration of the governor's declared state of emergency.
Okay.
There is no expectation by most people that are knowledgeable in this area that that is going to happen any sooner than the end of the year or into next year. And that by that I'm referring to the termination of the state of emergency declaration. So that could be that the restriction I'm about to talk about could be in place for a significant period of time.
The eviction process has changed dramatically. The rules have been turned over right now. Courts are still delaying the process, and at the same time, some courts are loosening up depending on counties.
The good news is that to the extent that the process is available to us, the courts are starting to loosen up. Orange County has opened up as far as doing unlawful detainer trials. They're being done virtually. The Los Angeles County courts have opened up for hearings. They have not yet opened up for trials, but they are expected to in the very near future. But the rules that we're working under from the Judicial Council are significant. They actually restrict and practically eliminate the ability to get a summons issued. The summons is the document that the clerk issues, which is served upon a tenant, which confers upon the court jurisdiction over that tenant and gives the court the authority to do what they need to do by way of entering a judgment, whether it be after a trial or whether it be by way of default.
This is what Bruce meant. The rules from the Judicial Council eliminate and restrict the ability to get a summons issued. Without a summons issued, there is no eviction. You see, there's so many restrictions right now for an eviction process that in order to do one thing, another needs to be done and another needs to be done. So a lot of the times our hands are tied. So you can file your case, you can file your complaint, you can file your summons, but the summons won't get issued. And without a summons, you can't do anything.
Unless you make an application and a judge makes a specific finding that the eviction is necessary because of, for reasons of public health and safety.
Okay.
As an example, we're talking with a client this afternoon about a gun that was brandished and a tenant who was arrested and taken away on Friday, and whether or not that situation would justify moving forward with the eviction process. And I believe that it does. But I can tell you that for those of us who have filed these types of applications before, they're very, very rarely granted. Clearly, non-payment of rent is not an issue of public health and safety.
Right.
You can't count the landlord going crazy because of a non-payment of rent as it being a public health and safety issue.
Right. Also, sheriffs have stopped lockouts, and again, every single day, things are changing during the eviction process.
Summons is bad enough, but even if you had a opportunity to default a tenant or to otherwise move forward with the process by requesting a trial date. As to the ability to enter a default and get a judgment for possession when the tenant has failed to participate in the lawsuit, that Judicial council rule has eliminated the ability to enter a default. Even if you already had a default entered before all this happened, the Judicial Council has eliminated the opportunity to have a writ issued, which is the document which the sheriff must have to facilitate his ability to enforce the judgment for possession. Even if you had a writ that was issued, we then have encountered issues not associated with the Judicial Council, but associated with the Sheriff's Office, and that is that the sheriffs have stopped doing lockouts because of COVID. Orange County has opened up and are rescheduling lockouts, and have rescheduled and have started to actually do evictions, lockouts at the properties. LA County is not there yet. There's talk about getting back up and involved. As far as getting things back on track, expectation is they'll be scheduling those things which were already scheduled but canceled first. And one of the reasons, so you might say, well, gee, why would I even file an eviction at all? Well, the answer's up in the air. I don't know, and nobody knows the answer on when we can actually file an eviction like we used to file evictions. One of the restrictions I didn't mention was the statute requires that a unlawful detainer trial be set. Once you're in a place where you can request a trial, it must be set within 20 days. That's the law. Judicial Council's new rule is it can't be set any sooner than 60 days after the request.
Okay.
So any sooner than. So we don't even know when trials are going to be back on track, but once we get to the place where the glut of cases that have backlogged are taken care of, because the other challenge is a lot of the judges are being reassigned to deal with other issues, primarily criminal, which are still having to move forward. So I don't know. There's no good answer as to when we can be back on a regular eviction case.
In rare cases, it makes sense to file an eviction case. The perception is that if you're already in the system, when courts start opening up and the process becomes more available, you already in the system will be able to move forward with the process a little bit faster.
If it can be used to facilitate an agreement between the parties,
okay,
which can be successfully negotiated, which is probably rare. It may also facilitate your opportunity, though, when the floodgates do open or the process is more available. If you're already in the system, as opposed to one of the thousands of cases that are arriving to file new cases, there's a perception that would make that you have the opportunity to be, hopefully you'll be processed before the new guys would be.
Yes.
Okay. So, but it's definitely a challenging time.
Well, there you have it. To recap, so it's important to stay in touch with everything that's happening, with all the changes in the eviction process, and to make sure that you are staying informed. If you have a specific scenario you'd like to discuss or know more about the eviction process and its changes every single day, give us a call. We'd love to help.